Court system of USA, judicial system of the United States of America. Generally, by court system of USA means how America administers justices. Under the Constitution of the United States, there are two series of courts, namely the state courts and the federal courts. Thus, the distinctive feature of the judicial system of America is that it contemplates separate and distinctive system of state courts and federal courts. The federal courts are established under federal laws and the state court under state laws. Under Clause 1 of Article 3 of the Constitution of the USA, it is mentioned that the judicial power of the United States shall be placed in a Supreme Court and those subordinate courts which shall be established by the Congress by law from time to time. In this way, the composition, constitution and jurisdiction of Supreme Court has not been described in the Constitution, and this has all has been left to Congress. Problems in starting American courts. Number one, overlapping of jurisdiction of federal courts and state courts. Number two, inconsistency regarding the formation of state courts. Number three, composition of courts in various states different from one another. Appointment procedure of the judges in various courts are not the same. Federal structure of U.S. courts. United States has 50 states, so we have 50 different court structure in the USA. But for all these 50 states, there is another unified court structure, which is federal structure of United States court. A necessity of federal court structure. The importance of federal judiciary is twofold. Firstly, in a federal form of court, there is a need of such a power which can adjudicate the disputes arising between the federation and different units. Secondly, American Constitution system being based on the principle of the separation of power of the government and the executive are independent of each other. Disputes relating to jurisdiction may arise between the two, and there is a need of federal judiciary to settle them. Law to be applied in case of federal jurisdiction of U.S. courts. By far, the largest number of civil suits in the United States is decided by state courts. Federal courts have jurisdictions only under special conditions. The fear that the court of the state might not afford complete justice to a party domiciled in another state explains the existence of federal jurisdiction in another class of case. In case of diversity of citizenship jurisdiction case, the federal courts shall be competent to try the case under certain conditions. But it was a difficult question as to what laws are to be applied by such courts. In the United States, there is no federal common law and 50 common laws of 50 states. The question vexed people for about a century. The Supreme Court's decision in Swift versus Tyson, 1842, it was established that in areas of judgment law, the federal court should apply not the case law of any particular state, but rules of federal law which were to be independently developed. This decision was based on the hope that in their way the decisions of the federal courts might gradually build a federal common law which might be taken over by the courts of the several states and thus form a point of around which American law might form. This hope had not borne fruit or successful. The courts of the states were far from the decisions of the federal courts and offer enough heat upon deviant rules. This gave litigants an incentive to try all kinds of devices to bring the case before the federal rather than the state courts or vice versa. depending on whether federal or state common law offered them the more favorably rule. These unfortunate effects induced the Supreme Court to take some initiative. In Erie Railroad Company versus Tompkins, 1938, the Supreme Court said, "We are abandoning our previous holding and decide that except in cases controlled by federal statute, federal courts should in principle apply the written or unwritten law of the state in which it sat." So by this case, moving to federal common law rule was changed, and it acted as a milestone for a total depart from a federal common law. Now, in diversity of the citizenship jurisdiction cases, the federal courts apply the law of the state in which it sits. Federal jurisdiction of U.S. courts. According to the Supreme Court Act 1925, the U.S. federal courts have the following 5 types of jurisdiction. This is called the federal jurisdiction of the U.S. courts. Number 1, those cases in which USA itself is a party. So when in a case USA is involved, it will not go to the state courts. Number 2, cases involving foreign officials if they are a party to a case. Number 3, cases in which citizens of different states of US are involved, provided that the claim in the dispute is not less than $50,000. This is known as a diversity of the citizenship jurisdiction. It follows for the rules of jurisdiction in diversity of citizenship cases that, to take an example, the federal court sitting in California can decide a suit brought by a Texas citizen for damages in tort against a Californian defendant. The question immediately arises whether the federal court should apply California or Texas tort law, or whether it may not have to apply federal tort law instead. Number 4, when the case involves the U.S. Constitution and other federal laws. Number 5, cases involving specialty matters, that is patent, trademark, copyright, customers, trust, monopoly laws, bankruptcy, etc. For example, any dispute concerning the WTO would lie to the Federal Court of USA. At last, it must be added that in exceptional cases, the state court might have concurrent jurisdiction over the 2 of the above-mentioned 5 issues, that is 3 and 4 case-related matters. Structure of the USA federal courts. The situation in the United States is rendered more complicated system of courts. It is clear from the fact that there are complete court systems not only in each of the several states but also in the United States. So far as federal courts are concerned, by Article 3 of the Constitution, the judicial power is vested in the Supreme Court, and such inferior court as the Congress may form time to time, ordain or establish. About 30 million cases are disposed by U.S. courts of them. 5% only are dealt by federal courts and 95% by state courts. In 1789, in one of the Judiciary Act passed by it, Congress exercised the power to create lower federal courts by establishing district courts as federal court of first instance and courts of appeal, the first set of intermediate courts, which purely appellate jurisdiction was established by Congress in 1891. So we find the federal Supreme Court, the courts of appeal and district courts in the arena of federal courts. The federal judiciary pyramid, like that in many states, is three-tiered. At the bottom are the district courts. From these courts on appeal lies to the U.S. Courts of Appeal, and from this appeal lies to the Supreme Court of USA. A brief discussion of the federal courts of USA is given below. Number 1, Supreme Court of USA. Number 2, Federal Courts of Appeal. Number 3, Federal District Court. Number 1, Federal District Court. At the bottom of the federal court structure in the USA are the district courts. As has already been said, it was the creation of an act of 1789 in which Congress exercised the power to create lower federal courts. Composition of the district courts. There are close to 100 district courts in the United States, many having only one, while other states with large population may be divided into 2 or 4 districts, each of which has a district court to bring such courts within the reach of the litigants. The Congress has divided the country into districts and provided district courts for each of them. Furthermore, many districts have more than one judge, so there are about 650 district judges who normally sit alone. The judges are all professional judges. They generally sit alone, although on occasion a bench of 3 may hear certain cases. Each district court has a clerk, usually a young lawyer who has just completed his university training, who assists him in his research. In civil actions seeking money damages, the Constitution guarantees a right to a jury trial if a jury is requested by either party. Statutes sometimes accord jury trial in other cases of criminal prosecutions other than for misdemeanors are conducted with juries unless the defendant waives that right. Court of Appeal. For appeals from the judgments of the district courts, there are 12 courts of appeals. These were formerly called the U.S. Circuit Courts of Appeal. Composition of courts of appeal. As has been said, there are 12 courts of appeal. The catchment area or circuit of 11 of them includes several states each, and there is one for the District of Columbia Circuit. There are 168 judges in these courts. In this course, 3 judges hear and decide cases. Function of the Court of Appeal. Generally, it decides on the basis of the brief of the trial courts. These courts may also hold trials. One of the judges writes the judgment. Judges may concur or dissent. When there is concurrence, the judges have to write their own opinions because these opinions may be useful in taking decisions by Supreme Court. Jurisdiction of the Courts of Appeal. The Court of Appeal has no original jurisdiction. It hears all appeals from the district courts, with a few exceptions of the cases in nothing federal, in nothing federal legislation and validity of federal and state laws, etc. The Court of Appeal has also power to review the judgment of the district courts that exercise concurrent jurisdiction with the Court of Claim in adjudicating claims against the United States. It can also review certain classes of orders issued by Federal Trade Commission and Federal Reserve Board. Though in 1925, Congress has given the final right of appeal in some cases, but the Supreme Court can call for such for review. Appointment of the judges of the Court of Appeal. The judges of the Court of Appeal are appointed by the President and are confirmed by the Senate. They hold office during their good behavior. Supreme Court of USA. At the head of the federal courts stands the Supreme Court in Washington with 9 judges. It owes its existence in the national constitution. The details regarding the organization and other matters of the Supreme Court have been left by the Constitution to the Congress for its determination. Article 3, subarticle Section 1 of the USA Constitution, it says, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress many from time to time obtain, direct and establish. May from time to time, sorry, I repeat it, please. Supreme Court in such inferior courts as the Congress may from time to time obtain, direct and establish. Composition of the Supreme Court of USA. Originally, this court was established in the Wall Street of New York City. Then it was shifted to the Philadelphia, and at present is situated in Washington, D.C. For conducting the trial, the quorum is of 6 judges. The Supreme Court of USA was established on 1st February 1970. Initially, it consisted of 1 Chief Justice and 5 other judges. The numbers of judges have been changed from time to time. In 1807, the number of the judges became 7, 9 in 1837, 7 in 1866, and again 9 in 1869. Presently, there is a Chief Justice and 8 other judges in the Supreme Court. Now, it sits with 9 judges in all cases. Working of the Supreme Court of USA. In order to keep the Supreme Court's workload within limits, an Act of 1925 gave the judges discretion to decide which cases were important enough to justify an appeal being heard by the highest court of the land. According to the normal practice, the Supreme Court will proceed to a decision of the merits if, after a summary consideration of the case, at least 4 judges are enough so doing. This is termed Rule of 4. If the application for appeal is subjected, no reason for refusal is given, though very occasionally one of the justices will very briefly say why he would not have chosen to hear the case. The court may decide the matter on the basis of briefs which have been submitted. Such a decision is normally unanimous and contains either no reason at all or only very, very brief reasons for confirming or quashing the judgment in question. In a specific group of cases, parties are entitled to a decision on the merits. Jurisdiction of the Supreme Court. The court has both original and appellate jurisdiction, but it exercises original jurisdiction in rare cases. Original jurisdiction of Supreme Court. According to Article 3, Clause 2, Supreme Court has original jurisdiction in the following types of matters. Number 1, such matters which are concerned with ambassador, public minister, and number 2, such matters in which Federation of United States of America or one or more than one state of Federation of America is a party. Appellate jurisdiction of Supreme Court. Except the above mentioned matters, in all other matters, the Supreme Court has appellate jurisdiction according to Jurisdiction Act of 1925, in which some amendments were also made in 1937. the court is vested with following appellate jurisdiction. Number 1. When the highest court of any state has given the decision against any law or treaty of the United States, or has declared such law of any state valid which is contrary to the Constitution or any law or treaty of the United States of America. Number 2, when any federal court of appeal of America has given judgment against the law of any state federal institution, law or treaty. Number 3, some special kinds of matter which have arisen due to the decision of the district courts. Apart from this, Supreme Court, through the writ of certiorari, can call for such cases for consideration from the state courts, in which the question of any provision of the Constitution or treaty is involved. The Supreme Court is not nested with advisory jurisdiction. Review jurisdiction of Supreme Court. The right of interpreting the Constitution can be said to be the most important right of the Supreme Court. Under this right, it has the right to consider the constitutional validity of the laws made by the federal Congress and state legislatures. Supreme Court can decide the constitution of state and federal laws on the basis of the following criteria. Firstly, whether the legislature has the right to make the disputed law. Secondly, whether the law has been framed on the basis of due process of law or not. It is to be mentioned here that annually about 7,800 cases come to this court, but only 100 of them are heard by the court on the merits. Session of the Supreme Court. The session of the Supreme Court begins from the first Monday of October every year and generally continues till last week of June next year. Sorry. Chief Justice can call special session of the court. Trials are conducted on Tuesday, Wednesday, Thursday, and Friday. On Saturday, judges make mutual discussion, and on Monday, give decisions publicly. Along with every judgment, the detailed opinion of the court is enclosed. Appointment of the judges of the Supreme Court. Judges are appointed by the President on the recommendation of the Senate. Consent of the Senate is essential. In absence of the consent, the Senate can reject the appointments made by the President. In 1970, the Senate rejected to approve the nomination of Harold Carswell by the President Nixon. Selecting process in the Senate is a difficult one. For public hearing. A public hearing of the person who applies to be judge is held. It is so much digging of the private life of the person who wishes to be the judge. For example, an essay written by an applicant during his school life may be taken into consideration in order to find out his normal age and previous history. In an appointment procedure, the alleged relation of the applicant Thomas with his clerk and Anita Hill, and her comment was taken into consideration and was discussed. At last, that district judge became the judge of the Supreme Court. In appointment claims, counterclaims, discussion continues up to 3 months. Most of the applicants become obliged to say, I just want to come out of the process rather than to be a judge of the Supreme Court. Many applicants withdraw applications during hearing, but once anybody is appointed a judge, he enjoys full independence, which is of immense importance in case of the administration of justice in USA. The terms of the judges are till his lifetime. They can remain, they can continue the office, or they can remain in the office subject to their good conduct. If any judge has served the Supreme Court for 10 years and attained the age of 70 years, or has served for 15 years and attained the age of 65 years, he can voluntarily retire. After retiring, he shall be getting his salary till his lifetime. In the concluding paragraph, it can be added that the federal judiciary of the United States is made up of the federal courts, which have the duty of explaining and interpreting federal laws, setting lawsuits between citizens of different states, and publishing certain kinds of law breaking. The interpretive duties of the federal court extend to treaties and agreements with foreign powers, and even to the highest law of the land, the Constitution itself. State courts in USA. The United States has 50 states, so we have 50 different courts structure in USA, apart from the federal court system. Each state has its own particular institutional organization, and it is therefore difficult to make valid generalization about the whole of the state court system. The sizes, population of each state differ widely, and different court structure has resulted. Sometimes it will have 2 degrees, whereas in about 2/3 of the states there are 3 levels: a Supreme Court, a Court of Appeal, and a Court of First Instance. Each state is free to decide as to what court it will establish, what their jurisdiction shall be, and how their judges are to be selected. Sometimes it will have only 2 degrees court, whereas in about 2/3 states there are 3-tier court systems. In about 39 states there are the 3-tier courts, and 11 states there are 2-tier courts. The organization of the court in each state differs widely from other states, but certain broad of likeness are found in them. Justices of the peace. At the bottom of the state judicial system, in rural and semi-rural regions, stands the justice of the peace, who have limited inferior jurisdiction in petty civil matters. The justices of the peace are elected from the area which they serve, and their courts are not the court of record. In some states, they are appointed by the governor. They hardly ever have any legal training, and the procedure they employ is a very simplified one. They administer justice on the basis of common sense. In fact, it is a very simplified, informal procedure of a resolution of dispute of very pretty matter. Number B, municipal courts. In the large cities, the lowest court are the so-called municipal courts, staffed by qualified judges. Although time jurisdiction is very limited, but municipal courts are conducted by professional trained judges. This court concentrates on highway offenses as traffic courts. Undoubtedly, this jurisdiction of the municipal court is very significant for this country, because this is a country which is highly mobile. This court deals with civil matters of small importance as a small claim courts. Private law dispute can also be settled by municipal courts, but obviously their jurisdiction is limited. In fact, municipal courts are additional courts. These are not within the 2 or 3 tier system of courts. Number C, county courts. Over and above the court of justice of the peace, different kinds of courts are established. In some states, county superior courts have been established, and in some states, intermediate courts have been established. In county courts, normally there is one judge. These courts exercise both civil and criminal jurisdiction in exercising original and appellate jurisdiction. In some states, by merging 2 or 3 courts, a district or circuit court has been established. The procedure of county court is very formal. To make things confusing, county courts are known as district courts. In some other places like federal district court, and to make things more and more complicated, in New York the county court is known as Supreme Court. From the decision of county court or district court, appeal lies to the Court of Appeal or to the highest court of the state. Appellate court. These courts have been established over the country, over the county counts or district courts. They are mainly vested with appellate jurisdiction. In 15 states, there are Court of Appeal. Number 8, Supreme Court of the state. On the apex of the entire judicial system of the state, there is a Supreme Court. In few states, it has different names. There is Connecticut. This highest court is known as Supreme Court. In New York, Maryland, the Court of Appeals. Usually, these courts have appellate jurisdiction, although in certain states, they also enjoy original jurisdiction in certain matters. The decision of these courts are final so far as the dispute is not concerning a matter of the state. Appointment of judges in state courts. Since judicial decisions demand mature judgment, knowledge of contemporary social and economic conditions through knowledge of law, highest personal integrity with ability to be impartial and non-partisan, it is prerequisite that judges should be selected by some method which will emphasize these qualities and minimize political considerations. The mode of appointment of judges in various states in the United States varies. In some states, judges are appointed by the governor. In some states, they are appointed by the legislature. In a state, they are appointed by a nomination committee, and in most states, judges are elected. The following is the picture as to the mode of appointment in various states. Mode of appointment by the governor, number 18. Mode of appointment by the legislature, number 3. Mode of appointment by nominating committee, number 1. Mode of appointment by election, number 28. It is clear from the above picture that judges in most cases in various states are elected. Election may be either, number 1, partisan election, number 2, non-partisan election. About in 12 states, the judges are elected by partisan election, and in about 17 states, the election is non-partisan. In case of election, anyone can contest as a judge, but generally only professional people are elected. In partisan election, parties help a lot in electing a judge. One important feature in case of partisan election is that once anybody is appointed judge by any party affiliation, they forget the past and do their best to be independent in exercising their judicial functions. Okay, thank you viewers. I'm Shamim. Thank you for watching.